Okay, good morning, class. We will discuss our discussion about environmental law. Right now, we will talk about the enforcement, especially related to the compliance first, and then how the enforcement enacted for the environmental law. As of course you know about the law will be enforced, and the effectivity of the law is depend on how it is enforced, and compliance as a part of the how society, how the business then knowing and then aware and also uh, uh, take their uh, compliant and also performing on environmental aspect is significant issues in the environmental law itself. And this should be highlighted and underlined that environmental compliance is not just a paperwork. It's not only about performing the obligation, the mandatory that result from the permit that a company have, or to performing the environmental management initiated by the environmental impact assessment, used as the mandatory requirement for obtaining the permit, but it should be defined and also understood as a framework as a perspective as how to do in the business process, because the compliant will be some some assurance that uh, or a tools to assure that environmental and social risks are minimized, because remember, impact is something that always happens, certain to occur. So it means environmental and social impact is something that will always happen from an activities. That's why the best thing that we need to do is to prevent, to minimize, whether it is environmental and social risk or whether it is environmental and social impacts. And to some extent, of course, remember when uh, you learn about the nature of business as usual is profit. It is a natural that projects are designed to maximize economic, social, and benefit, right? Economic benefit. But the idea, uh, what we know about the sustainable development is you not only think about how to maximize the economic benefits, but remember that you live in the social neighborhoods. So it's when you need to think about social benefit, as well as because your continuity depends on the raw materials that produced by the environment. So it means environmental benefit should be also uh, highlighted and pointed as the goals from your activities for the development activities. That's the goal of sustainable development. So let's go to the concept of how the integration of business permit, or especially risk-based, yeah, risk-based permitting, business permitting process, especially after the enactment of Law Number 6, 2023 on job creation, Undang-Undang Cipta Kerja, or what's so called in bahasa. So yeah, despite uh, on the controversy that still happen until today about how this law actually amputating the power of environmental law under the law number 32 2009, uh, to some extent how it is integrated, how the business permit then integrated based on the risk assessment. To some extent, provide the double layering protection for the environmental protection and management. So let's talk about how the idea of compliance then is significant and should be integrated since the planning activities and how it affects the oversight activities, the supervision, as well as the environmental enforcement leaders. Okay, so as you can see the left side of your screen, that when we talk about the basis and the basic idea of how integrating the risk assessment into the business permitting process is when a business or activities plan, they before they do the activities, of course, they need to have the permit. Okay, so the idea on how this integrating system is made possible under what's so-called the OSS RBA system, the Online Single Submission Risk-Based Assessment System. A system that, yes, it is controversial, yet with the latest developments of version 4 right now enacted, I think there are so many progress that has been made for this fourth installment of the OSS. But let's say right now, this system has more integrated the system, especially between the risk-based assessment and the impact assessment. That already been a system, a long system already been enacted in Indonesian environmental law system. Okay, so when this business or activities plan, they applying under the same roof, under the same system or as a survey system, then the system already integrated with the documentation that use as prerequisite standards. For example, about environmental carrying capacity, and then environmental protection and management plan, strategic environmental assessment, special planning, detailed plannings. And this is then designed under the law as what's so-called the basic requirement. There are three mechanisms or three document compliant document needed to be compliant under the basic requirement. First is the KKPR or special planning equitability. Okay, so this means your business or activities plan should be in line with the special planning. Okay, and then this if this already be done, the special planning inlining requirement, then you go through the environmental approval process. Okay, so let's say from this one, then you go with the special planning compliance, and then the OSS then give a risk screening for you, and then your activities, your business or activities plan, then categorize into whether you have low risk, medium low risk, medium high risk, or high risk. Okay, so after this risk screening, then the law required business or activities plan to having and performing under uh, the other standards, not only about KKPR as I said, but also the technical approvals. It could be less also like location approval, etc. It's very technical. But then after this approval is obtained, then and fulfilled, then it is integrated into the environmental impact screening, so mandatory impact screening under the AMDALNet or our Indonesian Environmental Impact Assessment System. And this AMDALNet then uh, integrated the requirement and then uh, give some uh, additional mandatory uh, mandatory compliance needed by to be fulfilled by business activities plan. And remember, in between KKPR, the special planning approval uh, and the environmental approval is a basic requirement that needed mandated to be fulfilled in sequential. So it means you cannot continue to environmental approval mechanism if you haven't got the uh, spatial planning approval. It is already been good. Yeah, even though the problem is how the integration of the spatial planning data from you can imagine Indonesia uh, consists of 35 sorry 38 yeah 38 right now provinces and 514 regencies or cities. So this a lot of numbers, right? And this is why how to integrate the spatial data from each region. It's still on progress and it's quite struggling, but we do still have to progress for that. Okay, so let's back to the screen that after you do the mandatory impact screening, then you will do the either environmental feasibility test if your activities then uh, categorized as a high risk activities and high impact activities. So it means you are obliged to have AMDA document, environmental impact assessment document. So you do the environmental feasibility test, and then after that, you will have the environmental approval, uh, environmental approval on environmental feasibility document, what's so-called EFD, environmental feasibility document. So as if you have this, then you go to another process, integrated process, the third basic requirement, what's so-called the PBG, the construction approval. So it means construction approval is only can be fulfilled after had you have the environmental approval. So the sequential is actually a very good initiation made by the document. Before go to the how the process after the construction approval, for the medium high risk, the activity, the business and activities plan, of course, do not oblige to do AMDA because it is medium high risk, but they need to do what's so called UKLUPR or environmental uh, management and monitoring efforts. They have the document and the process through the document inspection and then the system and then this inspection and then the standards already been uh, integrated in the system, as well as this approval should be made by the regional government. And for this medium high risk, you will have the uh, uh, some statement on the control and environmental management, control of environmental. So it's like a uh, statement on the compliance and environmental management that business or activities owner need to do doing while doing their business. So after this is approved, then you will have the business permit. And remember, compliance is not only like this some technical or administrative procedure. Because remember, when you have the business permit, it's actually you had the new rights, you have the right to do your business, etc. But also you will have the new mandatory, the new obligation to do. Your compliance will be defined. So how effective is your activities, your business activities in performing the activities, but also uh, obliged to the obligation that you have under the business permit. Okay, so that is why I think to some extent the integration of risk-based assessment permitting system in Indonesia uh, could provide a very good potential for the environmental protection. And what's the relation between this compliance and the supervision as well as the enforcement? These administrative uh, uh, activities and compliance, as I said, created the obligation. Then the supervision, the basic supervision, will be based on the effectiveness of this of the compliance that done by the business or activity owner. So if they have they do the compliance, so the supervision will say will like, okay, you do your obligation, you comply with the regulation, so that's good. You pass the compliance mechanism, right? So how about if then uh, they having some pollution defined by the environmental quality standard, okay? Environmental quality standard. So if a business or activities then created an impact, created emission that exceed the environmental quality standard, so it means they doing the environmental pollution. But to prevent that, the business owner, because they have this permit, they have the obligation to report and to submit environmental monitoring report uh, biannually. So every semester, every 6 months, they need to do the report and then submit it to the government. So that is the two-way supervision mechanism. One, supervision by the government related to how effective if the compliance done to suitable with the environmental quality standard, but also in the one side, also based on the reports uh, submitted by the business owner, activities owner, about their compliance, about their environmental management and monitoring effort, as I said before. So it means this is compliant, as I said, is not only some administrative thing, but also technical and also uh, framework that needed to be integrated in business activities. So if business then think compliant as a daily basis or a part of its business as usual, that is the best compliant uh, situation that you will have for the environmental uh, protection and management. Okay, so how about then? Remember in the concept of damage, there are environmental pollution, but also there are environmental uh, destruction, environmental destruction or environmental damage. Let's say environmental damage. This environmental damage happen when the impact then exceed the environmental damage standard criteria. So the government also have this. So the government also have the environmental quality standard or ambient standard. Uh, and then in the government also have the environmental damage standard criteria. In the uh, implementation, of course, uh, yeah, Indonesia, there is still less on the environmental damage standard criteria, but for the environmental quality standard, I think it's quite it's quite enough the availability on under the Indonesian regulation. So if then the sanction we will discuss later in the next slide. So then this is affect the compliance or not will affect to the enforcement. So for example, you already fulfilling all these administrative requirement. You have the business permit, you following all the procedure. So it means it, even though you're doing some pollution and creating some environmental damage, there are possibility of uh, the enforcement will only limited to the administrative sanction. Yeah, even though remember this is related to the standard. So to what extent then you violate the standard, that will be the difference. But basically, if you uh, like only uh, exceeding the environmental quality standard, so the law will uh, prefer the administrative sanction to be held for this. Okay, administrative sanction, especially, will be based on the supervision that met under the permit or under the technical technical compliance here. So it means administrative sanction could be sectoral based or environmental based. In sector, also it means the administrative sanction given by the sectors that manage the issues or the ministry that manage the sectors. For example, you are a manufacturer, so it means under the Ministry of Industry, the sanction, the administrative sanction, could be imposed. Yeah, even though, of course, uh, environmental ministry or environmental agency also could give you the administrative sanction and both. I mean, in the same time, also they have the right to do that as long as then uh, you are yeah breaching the or violate the standards quite serious. Okay, so then administrative sanction will be uh, supervise the implementation. This is what's so-called uh, the ultimum remedium principle. If administrative sanction then uh, defined or uh, evaluated uh, by the government that it is not effective enough on that, or if there is some repetition, some in another environmental damage, victim rises, and then also ineffective administrative sanction, as I said, then you can go to the criminal sanction on the litigation process. And as I said, these two mechanisms, administrative sanction or litigation process, can do both. Can do either in under ultimum remedium or can do both. Or even already have some victims serious environmental damage, of course, then you go straight to the litigation process on the criminal. Uh, Even though then, of course, can the government also uh, give some administrative sanction? Of course, the government can do that. Okay, so this is the you need to understand this to understand how the relevance and the relation between permitting as a compliance and the supervision on the oversight process by the government, and then how it affect to the enforcement process. Okay, so in short, in brief, I will discuss this in brief. Under environmental law, recent environmental law in Indonesia, especially on the revision based on the law number 6, 2023 about job creation law, as I said before. So the object of compliance, uh, this will be defined into two categories. So compliant based on the business permit or environmental approval. So this compliant will be oversight on the how the performing of okay, so it will be based on the how the compliant for technical approval, as I said, especially that it's related to the waste disposal, compliant, and then hazardous materials management compliant under these articles. And then the second one is about the environmental approval, as I said, especially related to the mandatory environmental uh, management effort that has been uh, described in the environmental impact assessment document. And then the third one, the compliance based on the writing statement of environmental monitoring, especially related to the UKLUPL or environmental management and monitoring effort. And the fourth one on the uh, approval compliance is related to the environmental approval, especially for the dumping activities. So this is the uh, the the what kind of dumping procedure that needed to be complied by business owner. Then the second one, of course, the object of compliance is related to the what mandatory obligation or what are the prohibition made by the regulation. So it means a company, a business activities, of course, uh, 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 described as doing non-compliance or non-compliant if they did not following the mandatory activities, or they are performing prohibited acts in the law under Article 69. And then the second things that you need to understand about what are the criteria of environmental offenses in Indonesia. At least there are four criteria, four basic criteria, okay? Because after the integration of business permit and how all the mandatory requirement, the special planning approval, the environmental approval, as well as the construction approval as the basic requirement. So there are four criteria. First, offense when you don't have the business permit. Okay, this will affect the differentiation of the sanction that could be imposed. And this differentiation and stratification of sanction is a good things in environmental law implementation. So this first one is do not have business permit, and then the second one, you don't have the business permit and you're causing damage to safety, public health, and environment. We call it under the law is CADWL, okay? Safety, public health, and environment. So safety either to environment or to human being. Yeah. So on the third one, you have business permit, but you're not comply to the required uh, obligation or regulated obligation or required standard specification instruments, but you're not causing damage to Kadwire. Okay, this is the third criteria of offense. The fourth one is the another thing that you have business permit, but you're causing damage to safety, public health, and environment. So this four differentiation is will affect to the enforcement that could apply. Okay, so the last thing I want to discuss about how significant is the oversight. So enforcement should be made based on the oversight, even though it is not uh, causality requirement. I mean, if for example, an activity is a business company, then created a pollution or created environmental damage. Should it be supervised and oversight first before we can do the enforcement, uh, or as long as there is some complaint, a complaint by the society, by the victims, for example, then you can go to the enforcement process. Yeah, to answer this, what can happen? What can be done? I mean, you can do the what's so-called the incidental oversight. So the government who have the report complaint from the citizen, then doing some incident oversight through the reported activities, reported business. This oversight, the main purpose of this oversight then to verify, verify the compliance, verify the damage, and also then uh, following up the complaint. And then how about if there is no need? Yeah, there is no need, especially because if then the damage is already been clear, proven, and already create some serious impact, that you don't need like distinct and yeah different process on oversight and supervising. You can just do with the the investigation process for it. So, I mean, the verification will be done based on the investigation process. Okay. So, after the oversight activities, so what kind of enforcement can be done for the environmental problems? So this is a basic, I mean, in every environmental law in the world will share this common type. So you will have the administrative sanction, you will have criminal sanction, or you will have the dispute settlement mechanism for it. So for administrative sanction, uh, the criteria or the basis, the easiest standard or easiest criteria to differentiate when administrative sanction could be applied if when your offense did not cause damage to K2L, safety, public health, and environment. Okay. Or K2L can also be related to the basic is on the everything should be based on the scientific proof. Okay, scientific proof, scientific evidence is significant in environmental law enforcement. So if you're not causing damage to K2L, or if there is some pollution, but then you have less breach of the standard, for example, you will have the written warning or governmental coercion or administrative fine or permit suspension or permit revocation. Remember why there are many of administrative sanctions. This will this is created because there will be a different situation on the administrative uh, offenses, right? And to what extent the damage, as I said, to what extent the impact of the offenses. So you either have the written warning because it is a minor offense, or you can have a directly to the governmental coercion or administrative fine, and even you will have some permit suspension, and then afterward the criminal procedure, the criminal investigation will be held. This is related to the to what uh, to what extent are the impact to the environment or the damage to the environment. So if you are causing damage, of course, the criminal sanction can be imposed directly. This is when ultimum remedium became primum remedium. That's the idea. Okay. So what kind of criminal sanction can be imposed? Either imprisonment. Uh, this is for uh, the direct polluters, and then criminal fine. This could be as used as additional sanction, or criminal sanction given to the company. And then you also have the corporate criminal sanction. This is related to the vicarious liability, or under the corporate liability, uh, the head, the 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 owner, and the top of chain of command in the corporate should be bear the responsibility and have liable as well as representing the company, the corporate in that. You will discuss later on the more specific aspect for it. Well, the last one is about dispute settlement. In general, you will have two kind of settlement mechanism. One is the out of court settlements. You can do with mediation, negotiation, ad hoc committee, arbitration, etc. And then you can go for the litigation process. Remember, from the dispute settlement, it is related to the civil action. So it means you can go either by a common legal suit, common law suit, or then you can go with the legal standing or uh, public litigation process. And then you can go with what's so-called the citizen lawsuit if you go based on the constitutional mandatory and constitutional right protection. And then you can also go to the uh, governmental uh, litigation. So governmental action. So the one who filing a lawsuit is the government agency. So you will discuss that more on specific topic related to that. So right now in Indonesia, aside the law, aside the criminal codes, we have at least two regulations that clearly define about how the enforcement initiated. One is the Ministry of Environmental and Forestry Regulation number 14, 2024, and also the Supreme Court Regulation number 1, 2023. It is a quite progressive edition made by the Supreme Court. So I think that's class for the introduction. Thank you so much. I hope you have a good understanding for this general definition of Indonesian environmental law supervision, compliance, and as well as the enforcement. Thank you.